The Senate Judiciary Committee will come to order. Call the roll, please. Okay, thank you. This should be almost the last day. We're going to have a hearing on our bills at 9. At 10 o'clock, we're going to interview candidates for the Court of Appeals of Virginia. And then we're coming back possibly Wednesday for more interviews from other judges. The first thing I want to bring to your attention is the members have on your desk a list of judges to be certified for recall status. Pursuant to the code, the Judiciary Committee is required to certify retired circuit court judges who wish to be placed on the recall list. The list of 8 retired or retiring circuit court judges is before you. If any member wishes to remove a judge from the list, please do so at this time. The committee operates by motion, and unless there's some judge, somebody would like to take off this list, the motion is available for anybody to. Thank you. Is there a second? Okay. All in favor of the motion to certify the judges on the list, these retired or retiring circuit court judges to be on the recall list, all in favor of that motion, it's a voice vote, I believe. All in favor say aye. Aye. All opposed, no. The motion carries unanimously. Okay. The first bill will be Delegate Levine's bill, House Bill 863. Other than ministers who may celebrate the rights of marriage, filing of marriage records. Okay, Delegate Levine.
Thank you, Mr. Chairman, members of the committee. This is the bill, yes, that allows parties to choose their own wedding officiant. It gets rid of the unconstitutional problem that favored religious people chosen over secular people, but more importantly, it's just a lot more practical for people to be able to choose their own officiant. It could be Uncle Joe who lives in Idaho. It could be your best friend Sue from college. It could be whoever the parties want without going through the incredible red tape that I had to go through in Alexandria, going to court 4 times, getting a notary, $5 bond, so forth. We started this last time, and Mr. Benjamin had some very good ideas, I think, to amend the bill that I think he can present to you.
Mr. Chairman.
First of all, let's walk through the problems of the bill, and then we can get to
Let me put it in good form first for you, if I may, Mr. Chairman. I've thanked Delegate Levine for working with me through the weekend, and for Kristen with also working very hard on this. These are minor but important amendments that need to be made on line 17. After the word officiant, strike the word who and insert comma in either such officiant or party to the marriage, and then strike the new language that appears on line 18. Let me tell you what the amendments would be, and then perhaps, Mr. Chairman, they could be moved as a block if any member chooses. On lines 28 and 29, strike the sentence that begins any person. The effect of striking that sentence, Mr. Chairman, is to remove the bond requirement for persons other than ministers. On line 44, strike the word one, replace it with the word a.
This is what line again?
That's on line 44. At the end of line 44, you'll see the word one. That should be a. And then on line 60, and Kristen tells me other bills have accomplished this, but to be consistent, on line 60, strike the words and race. Those are the amendments that I would suggest, Mr. Chairman.
All right, walk us through what the bill does then.
Well, with the amendments, just
all right, okay. All in favor of the amendments, say aye. Aye, all opposed, no.
Mr. Chairman, I think there's one additional one on line 66 to strike the word the at the end of the line and insert pursuant to section 20-16, either the, and then it would go on to read officiant or a party to the marriage shall file. So
That's
that matches up with
66, the word the, T-H-E, at the end of the line?
Yes, sir. And insert pursuant to 20-16, either the.
Okay, all right. Second, all in favor say aye. All opposed, no. Okay.
Walking you through the bill,
Walk-
Mr.
walk us
Chairman,
through it.
here's what the bill does. On line 17, this permits, currently, the officiant is required to return the completed copies of the wedding certificate to the clerk. Line 17 permits a party to the marriage to return the completed marriage certificates to the clerk. Lines 28 and 29, as well as lines 46 and 47, these remove the bond requirements that exist for people who are, for secular officiants and for persons who are members of religious societies who don't have ordained ministers. It's necessary to do that, Mr. Chairman, because the section that deals with ordained ministers does not require a bond in order to maintain a neutral effect, which is important for Establishment Clause, First Amendment reasons. You have to remove the bond requirement in those two instances. On line 44, 1 is changed to A, and the effect of that, and I think, was an unintended numerical limitation on religious societies. Lines 52 and 53, this removes incarceration as a penalty for conducting a wedding without a license, without a marriage license, or an officiant acting without authority. Line 60 removes the words "and race." Lines 66 and 67 also permit a party to the marriage to file the completed certificate in addition to the officiant. And then line 93, this repeals 4 sections of the code. 20-21 is a section of the code that says that the clerk is to furnish a list of unreturned licenses to the Commonwealth's attorney. Section 20-22 provides that the Commonwealth attorney is to determine the name of the officiant who did not return a license and certificate to the clerk. Lines 20 and Section 20-24 says that a minister who doesn't file the certificate is fined $25. Section 20-37 validates certain marriages that were solemnized prior to 1904. The bill presents essentially 2 policy considerations for the committee, Mr. Chairman. The first policy consideration is at lines 37 through 41. These provisions, as the delegate has told you, permit parties to a marriage to designate their own officiant. The only requirements is that the officiant must be at least 18 years old and cannot be a party to the marriage. There is no geographical restriction. There's no other condition. The second policy consideration is the repeal of 20-21 and 20-22. Those 2 sections are not well written. It's not clear how they work, but they are the only enforcement provisions, if you will, for situations when licenses are issued and then not returned.
Which line is that?
That's line 93. You'll see 20-21 and 20-22. They are repealed. Those are the 2 policy considerations.
Let me ask you this. I think you said any party to the marriage or the officiant can file the
Completed wedding certificate, yes.
anybody, the party, how you gonna make a party do it? Suppose they don't do it? I mean, what's the enforcement mechanism there?
Mr. Chairman, may I answer that question?
Yeah.
I think that no one wants marriage certificates filed and parties properly married more than the parties. I would argue the parties care about being married more than the wedding officiant. They want to be married. They got a license. They decided to be married. They went through a ceremony. They're the ones who are going to want to be married. It does allow the wedding officiant to return. That's actually current law. This actually allows for more people to return a certificate. One of the concerns raised was, this very old statute 100 years ago that you're going to find all the wedding officiants that didn't return their certificates, report to the Commonwealth attorney. It's a lot easier if a wedding officiant isn't doing it, if the parties just do it themselves. I've been talking a lot with the clerks of the court about this bill, several clerks, and what they say is it's only a handful that aren't returned in a year. they think it may be that the parties decided not to actually get married. But the way it works, at least in Arlington, is that if people go and they say, hey, I need a marriage certificate, maybe they need it for a loan or they need it for all kinds of reasons that people want a marriage certificate, they look, they see if it's there. If it's not there, then they can reapply and get it there. So the only harm of not returning a marriage certificate really is to the parties themselves, which is why they have an incentive to do it.
Mr. Chair.
Senator Morsi.
Let me give you a practical reason why you might want other people, other than the officiant, to be able to do it, i.e. the parties. A very good friend of mine, Lee Young, who was a former mayor of the city and a candidate for the House, married his daughter but passed of cancer. And 6 months, 12 months later, they're wondering, they couldn't determine what he had done. So that's a reason to allow the parties to the marriage to do it. But here's my question for the delegate. I've learned through the years that the quickest way to make sure a project doesn't get accomplished is to give two people the task. So I'm somewhat concerned that now two people, the officiant and the people that are getting married, each have the task or the authority to return the paperwork. Have you considered that and assuaged me that that's not a concern of yours?
Well,
I want to support the bill.
one thing we could do is we could have the clerk inform the parties that's been returned so that they know. I think that may be one way out of it. My goal was to make more return, not less. And I do understand your concerns, Senator Morrissey. I think maybe simply a notice requirement might solve that problem so the parties know it was returned. Having done 4 of these myself, I can tell you that I was in close contact with, I was the wedding officiant, close contact with the parties to the marriage. They were making sure I was doing my job and I was making sure they were doing their job. Part of the problem with all this red tape is that even under current law, it's still complicated because the parties have to return their license and the wedding officiant has to return the solemnization. Since the parties have to go back to the clerk anyway to return their license, it's easy just to return the solemnization along with it. I actually think it's simpler for them to do that. Yeah.
One final question. Right now, if the officiant doesn't return the document, the people get married before 400 people in a wonderful ceremony. They then have 4 children and they have their life. If that document is not returned, isn't it true that they are not legally married?
Actually, Mr. Chairman, Senator Marcy, that's not true. 2031 says if you believe you are married, you're married even if the certificate's not returned, and that's under current law.
Mr. Chairman, that's almost correct.
Okay.
There has to be a license. So long as the parties are solemnized pursuant to a marriage license, then any defect doesn't matter.
Mr. Chair. Senator Peterson.
Delegate, I'd sort of focus on the example of my own marriage. I was young when I got married. My wife was even younger. The last thing we were interested in was going back to the courthouse after the ceremony was over. So I think the idea of having the officiant turn it in is that you want someone who is a responsible person, someone with some standing in the community, maybe a pastor, maybe a judge, but somebody who has some gravity in the community that's going to make sure that the proper paperwork gets filed while these 2 young people are flying off to Bermuda or wherever they're going to go. And then, to be honest, having been a young person a long time ago, you're not interested in paperwork once you get married. You're interested in being with the person that you love. And I think that was the idea behind the statute. Do you have a response to that?
Well, I would say that, first of all, again, the wedding officiant can still return the paperwork. So this is an either or. And if they don't, as we pointed out, they're still married under 2031. It allows the parties to do it. When I performed these marriages, the parties still had to return their paperwork because depending on due to the complexities of Virginia law, if the wedding officiant, I was from Alexandria, the people I was marrying reside in Richmond, they had to return their paperwork in Richmond, and then I had to get the certified copy of it and return it in Alexandria. There's a lot of red tape here. So I had to go to court in Alexandria 4 times, file an order, get permission from the judge, get a notary, get a bond. But we had to do that anyway. So I would argue the parties already have to return the form, and this actually simplifies it because they can still do it.
Follow-up question.
Yeah.
Senator Peterson.
And leaving the paperwork aside, the gravity of your bill, as I understand, is that anyone can really be an officiant as long as they're an adult.
Chosen by the parties.
Chosen by the parties. And again, I come perhaps from a more traditional era that someone in the community that has some gravity, maybe it's a state delegate, maybe it's a judge, maybe it's a pastor, maybe it's someone who's willing to go through the steps, but it's not just anybody off the street. That marriage is something that's solemn, that it's profound, that it's meant to last, that it's meant to, in certain cases, bring children into the world. And so, again, you're looking for somebody who's not just, your drinking buddy from college, so to speak, somebody with some amount of community standing. I'm just saying, this is what the idea behind the statute was. You don't think that's important?
Well, I would say, Senator, that judges can still do it. Ministers can still do it. We don't change that part of the law. There are a number of designated officials that still the judge of every community has sort of the designated marriage officiants. They can still designate them.
Mr. Chairman, let me add to that answer as well for Senator Peterson.
Senator Benjamin. Senator almost. Benjamin.
It's important that the committee understand that there are two things that are required for a lawful marriage, and that is the issuance of a license and solemnization. We think of solemnization as being a wedding ceremony, but solemnization does not require any kind of ceremony. Moreover, I think the statutes clearly contemplate that first you must get a marriage license before you have the solemnization. However, in 2017, the Virginia Supreme Court ruled this way. The parties had a wedding. They didn't have the license. The rabbi informed them that they needed to get a license, and so they said they would after the ceremony. They eventually got the license. They mailed it to the rabbi, and about 30 days later, the rabbi returned it to the clerk's office. 10 years later, the parties are divorcing. The husband asserts that it was a void marriage because there wasn't a license issued before the solemnization. The trial court agreed, the Court of Appeals agreed, the Virginia Supreme Court said no. When the parties mailed in that completed certificate, that was the solemnization. So the answer is that although we think of a ceremony and a solemn proceeding, the law as interpreted by the Virginia Supreme Court now is that virtually anything that the parties do can amount to a solemnization.
Mr. Chairman?
Yes, Senator Boyce.
Question for the patron. So I support in context, in theory, in concept, what you're trying to do. I've performed a marriage for friends of mine in New York City. What Senator Peterson brought up, the fact that it might be best to have someone who is of standing in a community. What kind of concerns me a little bit is that one of the parties could turn in all of the paperwork. What if this wasn't a real marriage? What if someone is being coerced and forced into a marriage by, perhaps a younger person being forced by someone who is more powerful than them, and the more powerful one fills out all the paperwork and turns it in. I like the idea that there is a third person of standing in the community who has been with the couple, who has seen them, through this. I like the idea that you are bringing forward. I just have a little bit of concern, and I'm wondering if that has been addressed or if there's already a safeguard.
Mr. Chairman, Senator Boyce, the marriage license itself requires both parties to sign. So this isn't a case of one party fills out all the paperwork and the other person. They have to both show up at the clerk's office, who is a person of some authority elected in the community, and that office sees both of the parties to the marriage before they even issue the license in the first place. And I do have some people I know want to talk about this, but what I found is, and I've gotten emails on this as well, people say, my father or my teacher or my mentor who lives out of state wanted to perform the marriage. We can't legally do that in Virginia, and they can't. You cannot get married in Virginia today if the person of longstanding, a great judge from the state of Maryland, or your congressman who's in D.C., if they're not a Virginia resident, they can't perform the marriage at all under current law. This allows out-of-state people to do it. It also, yes, it allows the parties to choose. And part of this, I think, goes to sort of giving the right of people to make their own choices. We may not like their wedding officiant, but is it really the business of the state to determine that John and Sue should have this wedding officiant? It's their marriage, it's their lives. Maybe they pick an old drinking buddy, but I think most don't. I think most couples do pick someone of some kind of standing, but the out-of-state
Mr.
provision,
Chairman.
it's really concerning.
Yeah, Senator Sessler.
There are probably some couples that didn't stay married as long as we've been talking about this bill. And we either need to report it or carry it over for the year.
There's a lot of issues here.
Could I have some of the people speak to it?
Yeah, go ahead, have somebody speak to it.
All right. Got a couple of people that I know want to
No, this just.
give their view.
Yeah, do 2 minutes.
Okay, they're not gonna be that long. Go ahead.
Good morning, I'm Felicia Blackwell. I just wanted to say that I've had 3 daughters that has been married, and we've always discussed that I would perform their marriage. And that wasn't able to happen here in the state of Virginia. However, I just feel personally that marriage is sacred, and I think someone said that. I believe that that's the most important decision that we will ever make in our lives. And I feel that whomever the couple choose to be the officiant should be that person. And I think that they have the right to say, well, if it's my mom, and that's who I feel more comfortable with, that's who it should have been. And that's my
All
statement.
right, anybody else want to speak in favor of it? Okay.
Hi, thank you, Senator Edwards, and for the opportunity to speak in favor of HB 863. I'm Rick Clore, resident in Orange, Virginia, and a Baptist pastor. And I speak in favor of this because I've had to stand alongside those folks not bonded just so that a marriage would be legal, because they really didn't want a minister to do it, but they asked me to stand in, hey, make this legal for us. So it's going to simplify a lot of things, especially for persons that, officiants that the couple chooses that are not state residents. Make it a lot easier. And frankly, in ministerial circles that I talk to across the religious spectrum, we really find this requirement to be bonded kind of laughable. We don't necessarily like being agents of the state. We find that our authority comes from God more than the state, and so it's a little bit of an infringement on what we think. We really find this a little bit maybe a hangover from our colonial past when we paid taxes to a state church. And so we really would say, let's get rid of this law and free it up and let couples choose who they want to marry them. I believe in the sacred nature of matrimony, of course. And I do understand a lot of the arguments here today, but what I've learned is people, we as Baptists anyway, express freedom of the individual. And so we have to stand on the side of the person to choose, and so I stand in favor of HB 863.
You're aware that marriage is not just a religious matter. In fact, it might not even be a religious matter. You get a civil marriage. But there's a reason that the state has an interest in this. Equitable distribution of property, the tenancy by the entirety of the right of survivorship, the whole series of things, tax issues that flow from being married. Therefore, the state does have an interest in how it's done.
Absolutely.
And Mr. Chairman, let me clarify one thing. There is no prohibition in the law of anybody from anywhere performing or officiating over a wedding ceremony. You can designate anybody to do that so long as one of the authorized officiants also witnesses it and signs the marriage certificate.
True, and I will speak from a ministerial point of view. That's not sufficient for me because I take my role seriously as a minister. I will not just sign off on a document. I have to participate. So if they ask me to sign on it, then I have to bring in my faith to the marriage ceremony. So that is a challenge for ministers, not just to sign a document for someone else.
Okay, anybody speak in favor, anybody speak against it? I have some questions. I think some of the other people here have had questions. I'm really concerned about anybody doing this. And by the way, if you look at lines above this, any judge, et cetera, that's my bill, several years ago.
We're not touching that.
I've had several, no, I know it doesn't. But shouldn't there be, somebody of standing, for example, suppose a guy just got out of prison for axe murder, and he decides he's from Alaska, and he comes in and says he wants to, and the parties say, I want him to be the marriage officiant.
Well, I guess I would say, Mr. Chairman, that if the person is a minister, they can do it. But if they're not a minister, they can't, which is why the Seventh Circuit found this whole scheme unconstitutional. And I think they would find it unconstitutional in the Fourth Circuit, too. Because what it says is if you're an axe murderer and a minister in Alaska, you can marry them. But if you're an axe murderer in Alaska and you're not a minister, you can't, which is why I think the whole current scheme violates the First Amendment. And again, the Seventh Circuit agrees with me on
Mr.
this.
Chairman, we've discussed.
One at a time, let me see.
We did discuss this, and the Seventh Circuit had a different statutory scheme. With the corrections, the amendments that have been made, it's my opinion that our present statutory scheme is not unconstitutional.
Mr. Chair.
Senator McClellan.
Thank you, Mr. Chair. I mean, you will have someone of standing in the community involved in making sure that this marriage is legal, and that's the clerk of the court, who has to issue the marriage license and who has to also record the marriage certificate, which is then recorded with the Department of Vital Statistics. What we need to recognize is times have changed, and different generations have different views about who they want to conduct their marriage ceremony. There are people who want their best friend to do the ceremony. There are people who want the person who was involved in the couple getting introduced to each other in the first place to perform the ceremony. It's not for us to decide whether that's an appropriate person to perform the ceremony or not. It should be their right to decide who will perform the ceremony. But for the putting the stamp of the Commonwealth on that marriage, that is going to happen when they get their marriage certificate and when the marriage license is filed with the court. And for those reasons, I think we just need to recognize that for a whole new generation, 40 and younger, it is not as important to them, whether we like it or not, that a religious celebrant perform the ceremony, and we ought not, yes, and so for those reasons, I move to report as amended.
I don't know if we've adopted the, have we adopted the amendment? Okay.
Yes.
Who's supposed to file this with the clerk of court now?
It can either be the officiant, him or herself, or the parties to the marriage can file. And again, the parties to the marriage have to return the license anyway, so while they're there, they can simply file. And I think actually that's more convenient for them. But if they don't do it, the wedding officiant can still do it.
Yeah. I think it ought to be studied for a year, but whatever the will of the body is, there's a motion to report the bill as amended. Is there a second? Second. All right, all in favor vote aye, all opposed vote no.
All right, thank you, Mr.
Okay.
Chairman, members of the committee. All 100 House members supported, by the way, but thank you. No, I appreciate your time.
Thank you. Okay, now the next, got rid of that bill. The next bill is, who should we do it? Delaney, House Bill 798, I'm just going down the list here. Okay, employment, prohibited retaliatory action. Do we have a similar Senate bill?
So, Mr. Chairman, I think there was a similar Senate bill that specifically dealt with worker misclassification, and this is a broader non-retaliation bill that would simply allow any employee who sees that their employer, in good faith, believes their employer is participating in illegal activity to make a report of that claim without facing retaliatory action
Okay.
against them. And I know that Senator Peterson, I think, had some concerns with the language as it stands now, so we're back before you and at your expertise, the will of your expertise of this committee.
Senator Peterson.
Well, I wouldn't say I have concerns, because typically I'm the one representing the employee, but I just wanted to note that there's a whole sort of category of case law known as Bowman cases, which deal with retaliatory discharge and are considered an exception to the at-will doctrine under Virginia law. And I went through this weekend, and my biggest concern is twofold. First of all, line 39 has the reasonable attorney's fees being awarded to the prevailing party for this cause of action. Well, an employer can insure against this risk, and typically they'll have an insurance policy and they'll have if they get hit with some type of verdict, they can insure that risk. An employee has no such insurance. So if they lose a case like this and they're faced with a $100,000 legal fee, they're probably going to file bankruptcy. Higher, Scott says. So that's my first concern, that it's an employee protection concern. The second concern is there's all sorts of language in here which don't deal with actual legal violations, but rather suspected violations. Now, I employ people. A lot of people up here maybe employ people. You can have employees that may think you're doing something incorrectly, and at the end of the day, you're the boss. And you make that decision and you face the legal liability for what you do. And if somebody blows the whistle on you, and it turns out that they were incorrect, even if they had a good faith basis, you probably have a good reason to fire that person. And there's all sorts of situations where people, for whatever reason, can blow the whistle on an employer. And again, if it's a legal violation that has occurred, they should be protected, they will be protected, and they're protected under our current law. If, however, they do it for reasons that have nothing to do with, whether or not a legal violation occurred, but, they could be somebody that is not doing well in that position, and again, they raise issues or they go to the, in my case, we deal with confidential client communications. If they expose one of those communications or they go to the police or the Commonwealth's attorney, and as a result, you're going to be in a fear for your legal license, you need to be able to protect yourself and protect your clients. So the language about suspected violations or the employee's good faith, I do think that this bill can be saved, and there are changes I'd like to make to it. I have at least 4 changes I'd like to make. I know Senator Surville had sort of a more substantive amendment he wanted to make, but I guess it's just the will of the committee, what we'd like to do. But the main thing, Delegate Delaney, is I'm glad you brought this bill because, a lot of what we do in Virginia is not codified. It's case law, and this is actually codifying it, which is totally appropriate. But it's just, again, we need to have both protections on both sides that I don't think are here right now. So that was a very long prefatory comment.
Do you have some amendments?
Well, first of all, I'd take on line 39 where it says, the court may award the prevailing party reasonable attorney's fees and costs. I would change to put a comma after thereon, together with interest thereon, comma, as well as attorney's fees and costs. That means that the plaintiff would hold the attorney's fees remedy, not the employer. So I think that's the very first change I'd make to protect the employee.
You want to spell it out again? Line 39?
Line 39, after thereon, comma, strike the court may award the prevailing party. I'd just make it as well as reasonable attorney's fees and costs.
I'll second that.
All right, so I'll move that
The
amendment.
court may award attorney's fees
And costs,
and costs.
right.
And not the prevailing party.
So this would give the remedy solely to the employee.
Take out
Sounds good to me.
the prevailing party, right?
Right.
Or take out to the prevailing party.
Right.
All right.
I make that a motion. Yep, we got a
Okay,
second.
is there a motion made and seconded to take out the words "to the prevailing party" on line 39?
Take out the words, the court may award to the prevailing.
Right, just comma after thereon, as well as reasonable attorney's fees and
I
costs.
see. All right, take out, put a comma after thereon, take out the period, strike out "the court may award to the prevailing party." Okay, all right. All in favor of that motion, the line amendment, say aye.
Aye.
All opposed, no. Motion carries.
All right, next, go up to line 29, where it says authorize an employee, this section does not, so these are the carve-outs. This section does not authorize an employee to make a disclosure of data otherwise protected by law or any legal privilege.
Which line again?
29.
Line 29.
So add the words or any legal privilege.
You want to take out that entire line?
John, just
Go ahead, I'm listening.
Just add the words or any legal privilege after protected by law.
Mr. Chair, Mr. Chair, I'd like, who determines whether a legal privilege exists?
Well, that would be the fact finder. In other words, all this is going to be litigated.
All right, so let's do this again. On line 29, it would read, authorize an employee to make a disclosure of data or any legal privilege.
No. A disclosure of data otherwise protected by law or any legal privilege.
Okay, any legal privilege at the end of the line. All right,
Now, let me have to do this.
all right, let me read it again. On line 29, it says, This section does not, one, authorize an employee to make a disclosure of data otherwise protected by law and the ad
Or any legal privilege. Right.
Is there a second?
Okay, I'll second it. for the
Any
sake-
discussion? Any council, anybody want to weigh in on this? Okay, all in favor of that motion, say aye.
Aye.
All opposed, no. Motion carries.
Okay, now the last two are sort of more to the substance of what I said earlier, but they're important, and that is, and I'd kind of take these in a block because they deal with the same issue. On line 16 and 17, it says, or a person acting on behalf of the employee in good faith reports a violation or suspected violation of any federal or state law. And then if you drop down, you have under line 22, refuses an employer's order to perform an action that the employee believes, which belief has an objective basis in fact, comma, violates any federal or state law or regulation. And again, this comes back to my earlier point that you could have an employee who refuses to follow out your instructions as an employer because they quote unquote have a good faith belief that's illegal. Well, their good faith belief may be completely erroneous. I mean, it would be if and this is something I do all the time, I'm trying to serve papers on a witness or on a defendant, and I don't know their address, and I have my secretary call them and say she'd like to make an order of flowers delivery. Can she get their address? We get their address, and then we serve them with the subpoena papers. That's totally legal. In fact, that's called being a smart lawyer. But if my secretary says, I'm not going to do that, it's a violation of federal law. And so, okay. I mean, at some point you have to be able to run your own business. So the edit I would make is where it says reports a violation, I'd take out the or suspected violation.
Which line again?
On 16 and 17. Just in good faith reports a violation. I'd take out the word suspected violation. So it keeps the same content of the bill.
Okay.
And then the second part of that, which says refuses an employer's, down on line 22 and 23, refuses an employer's order to perform an action that, and then I take out the employee believes part. So I just say perform an action that, on down to the next line, violates any federal or state law. Again, if I ask an employee to do something such as break into somebody's house and steal files or take a picture of them in a compromising position, and that's a violation of state or federal law, then that's illegal. But if it's just their belief,
Okay,
and
so there's a motion.
right, to make those two,
amend
I move
line-
those two amendments.
Line 16,
And I can hand these to staff.
which it would read, or a person, this would be, couldn't be discharged, et cetera, for one, or a person acting on behalf of the employee in good faith reports a violation of any federal or state law.
Mr. Chair, I'll just
strike out the term or suspected.
Just strike out or suspected violation, and then down to 23, strike out the employee believes, which,
Let's do one at a time.
okay,
All right, strike out or suspected violation,
right.
okay?
I make that motion.
All right, is there a second? Second. All in favor of that motion, say aye.
Aye.
All opposed, no. And then dropping down to.
And then 22, 23, which is basically the second half of that, again, just strike the employee believes, which belief has an objective basis in fact. You just strike that language and just keep it as
Okay,
a violation.
There's a motion to strike on line 22, the words that the employee believes, which belief has an objective basis in fact. Wait a minute, is that right?
Yes, sir.
Okay, so it would read, refuses an employee's order to perform an action that violates
Violates any
federal or state law, et cetera.
Right.
Okay, so we strike out the words, the employee believes, which belief has an objective basis in fact. All right, it's moved and seconded that those amendments, that amendment be adopted. All in favor say aye.
Aye.
All opposed, no. Okay, now, anybody else want to weigh in?
And can I just speak to that?
Yeah, Senator.
And now, having done some very minor surgery, I like this bill. So.
Thank you, Senator.
Okay.
Mr. Chairman,
Yeah, Senator Searle.
I have a question for council. So, right now, Bowman, existing common law remedy for Bowman claim applies to discharge. I don't believe the Supreme Court has extended it beyond discharge. But discipline, threaten, discriminate, penalize, or any other retaliatory action. Has any other state gone that broadly? Because the way I read this right now, an employer, like can't even like sort of put an employee like on probation to investigate a problem, to figure out something before they take an action, the way this is worded. I mean, firing is a pretty clear line, but, you know, say somebody comes to you and they say something and you say, you know, I'm gonna put you in the box for a minute while I go figure out what's going on. Now they got a lawsuit, the way I read this. Is that, do you all know whether anybody has gone this far in any other state?
Staff?
Mr. Chairman, we do not have the answer to that question.
Mr. Chairman, I guess I would maybe also ask with the other more narrow legislation that we've passed this session that deals with misclassification, I believe it has the same set of words, but I'm again at the will of the committee as far as how far you'd like to go with this
Mr.
broader.
Okay.
Further question?
Yeah, further question.
Or actually, I have an amendment. So we've passed other legislation this session regarding employee rights. Specifically, I believe it was our wage theft statute, which provided for a class action remedy, which I believe the patron voted for a couple times. And I kind of wonder whether this statute has sufficient teeth in it without such a remedy in it. And so I was going to suggest that we, given this committee, the policy this committee adopted was to approve class actions, that we amend this bill to include my class action bill, which is Senate Bill 1043, so that this bill has an appropriate remedy so that if multiple employees are disciplined, so for example, if they want to start a union and the employee fires everybody because they tried to start a union, then the entire group can actually bring a lawsuit instead of having to file, 20, 30, 40, 50 suits separately and clog up the courts. So I would still move that. I make that motion.
Is there a second? Second. All right. How, we don't have the language to that, but we have passed the class.
Mr. Quagley, I would prepare to substitute, Mr. Chairman.
Okay.
Does it include Peterson? No, it doesn't.
Yeah. Okay, and how many pages is this? Got a one-page bill, and now we got a two-page, three-page class action. All right. This is identical, other than these changes, identical to the bill we passed out before, correct?
That's correct, Mr. Chairman.
What's the status of your bill, Senator Sherwood?
It's pending in the courts committee this afternoon.
Okay. Okay, any discussion on this?
Mr. Chair,
Yeah, Senator.
before we vote on this, could I just move that we adopt the amendments to this substitute that we just adopted?
Yeah, the amendments that we just adopted, line amendments, we adopted with regard to the substitute. All in favor of the motion, say aye. Aye. All opposed, no. Okay, we've got the substitute for us with the class action on top of it. Would the patron have any comment?
Well, Mr. Chairman, I think I'm happy to see this bill moving forward, and if, depending on the will of the bodies, we can keep moving it and hopefully get some progress this year on this issue.
Okay, is there a motion to, first of all, we adopted the substitute, didn't we? All right. Is there
Chair.
any discussion? Yeah, Senator Morrissey.
The operative words are getting some action this year as opposed to carrying it over for a year for studying it. I just can't help but say that.
It's been moved and seconded to report the substitute as amended. All in favor of the motion, vote aye. Aye. All opposed, no. Where are you going?
Ayes 9, noes 5.
Ayes 9, noes 5. The motion, the bill is reported as amended. Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Okay. Now we got 1501 Collins, modification of spousal support, House Bill 1501. I'm just going down the list. Delegate, hope you're next. 1501. Okay, what does this do?
I feel like I'm in the middle here.
Mr.
Bill
Chairman.
for the Family Foundation, right?
Mr. Chairman.
Yeah,
No.
yes, Senator.
I believe this bill is identical to the bill I passed earlier, and having said that, I just think we just need to move to report it, moving on. I don't think we need to have a discussion about it.
It just very simply,
Well, the note I have, Mr. Chair, is that it deletes some language
yeah.
that you added to the code in 2018.
Could council confirm it's the same as the bill we passed? It's different? Oh, I'm sorry. I withdraw my motion then, I'm sorry.
It deletes, the information I have is that it deletes a bill you wrote in 2018, or you had introduced in 2018.
Mr. Chairman, in 2018, Senator Surville had a bill to add the language that you see on lines 45 through 46. I think the problem that the Family Law Coalition saw was that these exact words have to be in every agreement, and they were not always put into the agreements in that exact form, so the courts were rejecting them. So the Family Law Coalition's suggestion was to say that words like that needed to be in the agreement.
Yeah, okay. All right, is there any?
Yeah, this was your bill last year, but because you put in, excuse me, Mr. Chairman, I apologize, but because it's in parentheses, the courts are reading that exact language has to be in every agreement.
Yeah. Is there a second? Any further discussion? All in favor of the motion to report House Bill 1501, vote aye. All opposed, vote no. Okay.
That's 1301.
Okay. Thank you very much.
Thank you, Mr. Chairman.
Delegate Hope, and this is also Levine's bill too.
This is
Okay.
not Levine bill.
No, it's your bill. But
My
his
bill is
name
not a
the
Levine bill.
co-sponsor.
House Bill 1530. It is not a Levine bill.
Okay. Okay.
But it has nothing to do with marriage, but it has something to do with divorce. And I have Jennifer Bradley here who specializes in this area, who brought me this bill, and she can answer some technical questions. But what we're trying to do here is want to join 47 other states that have removed the corroboration requirement for no-fault divorce. Only Arkansas, South Carolina, and Virginia are the 3 states. DC's also done away with it as well. And I asked Jennifer to come up here and explain a little bit more. But if you look at what we're trying to do with the language that we're deleting, it's almost impossible to verify that the person that's coming in.
And Mr. Chair, that the questions are, to the best of your knowledge and belief, have they separated at such and such a date? To the best of your knowledge and belief, was the separation permanent, or is there any hope of reconciliation?
Yeah.
To the best of your knowledge, that it is kind of a, I see what you're trying to do.
So you can do this by affidavit and not just by deposition.
Well, you can already do that, Mr. Chair, but what they're saying is that you don't need the
Okay.
corroboration.
Okay. Got somebody speak for it?
Good morning. My name is Jennifer Bradley. I'm a female attorney in Arlington. I've been practicing for 12 years. I formerly practiced with Betty Thompson, who was the former chair of the Family Law Coalitions. I know some of you are familiar with her. I asked Delegate Hope to sponsor this bill because of the almost daily frustration that my clients are experiencing from having to find a neutral third-party witness to verify under oath that they have, not just to the best of their knowledge, but the statute says that they have personal knowledge that the parties have not cohabited since the date of separation. It is impossible for a third party to have personal knowledge, especially when now the parties can be separated under the same roof for the entire period of separation, and especially when the parties have been sometimes separated for 3, 4, 5, up to 10 years, even more sometimes, before they're even finalizing the divorce. There's just no one qualified to actually state this statement under oath that's true. It's also inconsistent with the requirement for the no-fault grounds in the code that the parties be separated for at least 1 year. This statute requires that the affiant affirm they've been separated since the date of separation, which is a different requirement. The witness also has to have personal knowledge that it's been either party's intention since the date of separation that the separation be permanent. Again, it's impossible for a third party to know someone's intention for an extended period of time, a year, 3, 4 years at a time. The witness has to testify that at least one of the parties was a bona fide resident and domiciliary of Virginia for at least 6 months prior to the suit being filed. Oftentimes, I have clients who are not Virginia residents. They're getting divorced in Virginia because that's where they last lived as husband and wife. And their witness also doesn't live in Virginia, has never lived here, may not have ever met the other spouse. And they're signing these affidavits having no idea, they don't have personal knowledge about whether the other spouse was a Virginia resident. They don't know, even if they do know the other spouse lives here, they don't know what bona fide resident and domiciliary means. They're just signing off on a piece of paper that they've been asked to sign. The witness has to testify that the wife is not known to be pregnant from the marriage. They might, again, the witness may not even know the wife, let alone, even if they do, they have no way of personally knowing whether or not the wife is pregnant. The only way they would know this is if one of the parties informed them, yes or no, she's pregnant or not. None of the testimony that the witnesses are being asked to sign under oath in an affidavit would be admissible in a normal evidentiary hearing in court. It's lack of foundation, it's hearsay based. The Family Law Coalition is here. They're opposing the bill for two reasons. They say that we don't want to make it easier to get divorced in Virginia. So that I say, and my partners and my combined 6 years of experience, no one has ever declined to get a divorce because they hear they need corroboration. They just say, well, this is going to be a little bit more difficult than it already would have been. It's going to be difficult to find someone who's willing to sign something under oath that they don't know to be true and that they don't understand. Divorce is already the most difficult situation most people will go through in their lives, and we're just adding to the difficulty and embarrassment of that.
Let me ask you, because I do some of this too, that I've never had a problem with, they usually say something like, it's my understanding, or based on, I believe this is true, or something like that. And I've never had any judge say, well, that's not good enough.
Well, it's, again, they're saying that they have personal knowledge. I mean, the code requires personal knowledge, and we get around that by saying, is it your understanding or do you believe? Is it to the best of your knowledge? But that's not what the code says. The coalition is also saying that they're worried that divorcing spouses will then lie under oath to get divorced more quickly. But that's ignoring the fact that 9 times out of 10, when you have divorcing spouses, it's not a mutual decision. One spouse is leaving, the other spouse is being left. The spouse that's being left is the corroboration that we need. They're not going to agree to an earlier separation date, especially when it affects their property rights. Yeah. The earlier the separation date, the smaller the marital estate. So,
well, let's see what the some other people say about this. Okay,
sure.
Thank you.
Thank you.
Good morning, Mr. Chairman and members of the committee. Valerie LaRue, I'm the staff attorney for Family Law and Child Welfare at the Virginia Poverty Law Center. And in that role, I hear from self-represented litigants from all across Virginia, from Galax to Fairfax, about problems that they're having in trying to get divorced. And I would say the number one problem that I hear from both self-represented litigants and circuit court clerks about people who are filing their own divorces, and we have an online system that allows people to create their own documents to take to circuit court to get divorced, because many people in Virginia want to get divorced, can't afford an attorney and the legal aids, even though most of them have 1 or 2 dedicated staff attorneys to handle divorces, cannot deal with the caseload of people who qualify for legal aid and want to get divorced.
So you support the bill or not?
I support this bill, absolutely. The witness affidavit is one of the biggest things that hangs people up and causes headaches for circuit court clerks. So yes, I support the bill.
Is anybody opposed to the bill? Okay.
Mr. Chairman, members of the committee, Dan Gray with the Virginia Family Law Coalition. We do oppose the bill. This is a major policy decision. In order to get a divorce in Virginia on uncontested grounds, if you don't have children, you have to be separate and apart for 6 months. If you do have children, you have to be separate and apart for 1 year. And part of the reason that the code requires corroboration is to verify that that period of separation has been fulfilled. And our members, our divorce attorney members, are very familiar with clients who want to backdate the date of separation. As you heard the witness testify, you can fulfill the period of separation within the same residence. You don't even have to be physically separated. The public policy behind requiring that date of separation is to make the divorcing parties think about that decision. We are trying to promote marriage, and the period of separation clearly indicates that the public policy of this Commonwealth is to not make divorce that simple to be granted. So when you have a corroborating witness, they got to verify at least 2 things. Number 1, that period of separation has been fulfilled. And number 2, that the people who are moving for the divorce in Virginia have been bona fide residents and domiciliaries for at least 6 months prior to filing. We do not want Virginia to become a divorce mill and to make it too easy to have access to our courts to get the divorce.
Mr. Chair, Mr. Gray, how do you respond to the testimony before? I mean, I've had clients 100 times probably in the last few years and you say, that they, throughout the deposition or affidavit, it's to the best of my knowledge and belief, that doesn't meet what the code requires, does it?
No, we think it does meet the requirements. You know, you don't have to actually be present at the wedding to verify that the parties have been married.
But how do you know they're intended to stay permanently separate and apart?
And that's one of our biggest problems with the bill, is that there has to be some public element to this. You have got to declare not only that you are separated, but that you intend to get a divorce. You got to call a friend. You have to call a family member. It can't be a secret between two people. And so the act of telling other people that, number one, you're separated, number two, that separation is not just because of a business trip, or not just because you're tending to your ailing relative, but that you are separated because you intend to get that divorce. And if you take away the corroboration requirement, it's going to make it far too easy for people who are now allowed to be separate and apart within the same residence.
Mr. Chair.
Senator McClellan.
Sorry to interrupt. I have two questions. These are uncontested divorces, right?
They are uncontested divorces when it is a 6-month separation and there is an agreement. It is not necessarily uncontested when there is a 1-year period of separation. That is a key difference. When you have a 6-month, you can get a divorce on a 6-month separation if you have an agreement that resolves all your issues. So in that very specific circumstance, both parties are aligned. But we have multiple cases where when there is a 1-year period of separation, there may not be an agreement. The parties may not even agree that they're separated.
Right.
So,
but my question is the quality of the evidence. I mean, a person doesn't have to have been there when they separated and somebody said, hey, I'm leaving permanently. I've done a lot of these, and a lot of times the people don't really know that much, but they know enough about the parties. They can say, it's my understanding, it's my belief, and the courts say that's okay, isn't it? I mean, and I've never had any court say that's not good enough.
Mr. Chairman, that's been my experience and the experience of the members of the coalition.
Mr. Chair, I had another question.
Yeah, Senator McClellan.
And this is for either Mr. Gray or Delegate Hope. And did I hear you say that there are only 2 or 3 other states that require this now?
Arkansas and South Carolina.
Follow up.
47 other states plus DC have eliminated this requirement.
Follow up, have those states and the district become divorce mills?
Not that I'm aware of, Senator.
Thank you, Mr. Chair.
Yeah, Senator Boyska. If you move to report, is there a second?
Second.
All in favor of the motion to report, vote aye. All opposed, no.
Ayes 7, no 6, 1 abstention.
Snuck out of here.
Thank you, Mr. Chair.
Congratulations. Oh, 7 to 6, okay. Now that completes the docket, I believe. Is there any other? Okay, well, we'll come back. I believe it's going to be Wednesday for a few judges. And now we're going to go across the hall and we're going to interview candidates for the Court of Appeals, Virginia. Okay, we'll do it together with the House. Okay? And with that, the